Hello everyone, and good evening to this evening's webinar. Welcome. On the screen at the minute you've got our new website address and the new email we'd like you to use. We've finally got that all functioning. I will put this up again at the end, so if you're not currently aware of our new website, I suggest you go and check that out after the webinar. So for those of you, most of you on the line are Reiki Guild members, but for those of you who are not, the Reiki Guild is an organisation for Reiki practitioners and teachers that honours the lineage and teachings of Mikao Usui. Now, we're a highly professional association and community of teachers and practitioners, as I said, and we offer training and support, such as this evening's webinar. We have networking and also other fun events throughout the year. We at the moment are trying to have more going on around the country, so certainly we've got a few Christmas get-togethers other than our normal London one. So if you want to find any more out about the Reiki Guild, I suggest you have a look over at our website. Now, before we get started, I've just got a few technical issues for those of you who may be new to the webinar. For a start, if you can't hear us, check that your speakers are on and that you've got no loose connections anywhere. Very often there's a simple explanation. For instance, you've got mute pressed. Now, sometimes our internet or yours drops out for a few minutes and you lose the sound, but it usually comes back quite quickly. I have actually been having internet problems today, so our speaker, David, is also an organizer of this, so if the worst happens, he should still stay on the line. Now, you should be seeing a chat box in the top right-hand corner of your screen. Unfortunately, if you're watching on an iPad, you may see it, but it doesn't necessarily always work. Now, you can type questions and comments in there, and I will be able to see them as we go through the webinar. And we'll certainly be taking questions at the end, but if I see any relevant questions or comments coming up in there, I may well read them out. At the end, if we've got time for live questions, if you've got a microphone, I can also open up the mic so you can ask your questions directly. Now, there's also a little icon that looks like a glove, a little hand, and you can also click on that to attract my attention. And as we go through the presentation, and I try as much as possible to keep an eye on there, but bear with me if I don't get to you straight away. And finally, if at the end you want to ask a question live, you may find that having headphones is helpful, because sometimes if your internet isn't that great, the sound isn't very good with your computer's microphones. So I think that's everything. So without further ado, we'll get on to this evening's presentation. Now, when we put out the webinar, we called it Legal Requirements of Running a Practice. But as David pointed out, he's not actually a lawyer, so we're calling it Running a Reiki Practice now. And we will touch on a few legal things, and I'm sure if you've got questions, David will be able to answer them or know where to find the answer. So this is going to be much more a general talk about the practicalities of running a Reiki practice. And as I said, with me this evening, I've got David Balin, who's Managing Director of Balin's Limited. And if you have group insurance through the Reiki Guild, we have our insurance through Balin's. And Balin's are one of the largest independent insurance brokers for natural health and wellbeing professionals in the UK and the Republic of Ireland. I'm Louise Carden, and I'm organising this webinar on behalf of the Reiki Guild. So just a few things about David before we start. As I said, he runs Balin's. He's Managing Director of Balin's Limited, and he does quite a lot of guest lecturing, and he's a regular lecturer at various universities and runs training and writes articles for professional journals. And quite unusually for an insurance broker, I would think, he's been involved in the natural health movement for over 30 years and has connections with many different professional organisations, including being a trustee of 3. And David was on the steering committee for a national research body for osteopathy. Again, probably unusually for an insurance broker, he was originally a professional musician and yoga teacher.
I like magician.
Magician, okay. You can be a magician as well. I'm sure you are. Professional musician, magician, and yoga teacher. And he still finds time to play music and to compose semi-professionally. That must calm you down through all that insurance brokering, David.
I don't know. These days there's so much with computers. And
Welcome to GoToWebinar, Webinars Made Easy.
introduction.
Yep.
I hope you can all hear me clearly.
Yep.
Can you?
Yep.
Would you like me to ramble in now, or do you
Yes.
have other things you'd like to say?
No, my microphone just pulled out then, so we should be good now. So if I'm going to hand over to David, I will get on looking at the question and chat box, and I'm just going to mute myself so you don't have any sound from me. So over to you, David.
Okay, fine. Well, hi everybody, and thanks for joining. And I think it's well, it's very nice to be invited. I think it's more like 40 years plus now I've been involved in the natural health movement. Time flies, etc. Whilst I'm not a lawyer, I do have quite a bit of understanding of how the law operates in respect, in a general way, to practice. So I thought I would start by just keying you into some of those ideas and principles. I also hope you can hear me fairly clearly, because I'm not using one of these plug-in mics. I'm using the mic on the computer. So do send comments to Louise if it's not coming through very clearly. And also please do ask questions. I'm quite happy to stop rambling through the subject matter and dealing with any interesting things that pop up. But my theme has to be to support you in your practice and to hopefully give you some practical information. I don't know how many of you are new or how many of you are experienced practitioners out there, or who may actually be watching the recording. So I'll try and cover some basics as well as some advanced stuff, so that hopefully you will all get your information needs met. I think the first thing to say is that healing and Reiki are definitely considered a complementary therapy. You all know about the House of Lords report. It brought healing and these kinds of modalities, Reiki, healing, energy medicine, all the rest of it, firmly into the camp. And because of that, we've all tried to improve standards, talked about legislation, regulation, and all these good things. But at the end of the day, the practice is about you, and it's about the energetics of practice. As some of you know, I've been involved in the healing movement a long time, and I do healing. And I've always been very interested in the way energy flows in businesses, and how the actual business, or the practice, if you will, somehow reflects who you are as a person, and your intent, your focus, how you visualize, how you feel about yourself, how you feel about earning money for what you do. All these sorts of issues feed in. And so when we think about the practical side, the grounded side, if you like, of practice, sometimes we just feel, well, that's not so interesting, maybe that's not so important, let's put some of those things to one side. In terms of understanding the law, it's fairly straightforward. You have the law of tort, or the law of negligence, and that governs the way people relate and deal with one another. And at the end of the day, if you're alleged to have injured someone, or damaged their property, or caused them some kind of loss, or some kind of impediment or problem, then the law says actually that person can seek recompense against you. Now, the way that works in England, it's a bit different from the continent. As you probably know, on the continent, the law says you can do things. If the law isn't there for allowing you to do things, then you can't do it. In England, it's the other way around. Unless we say you can't do something, then you can get on with it. And that's pretty much what's happened in the natural medicine movement. The thing, though, is that even though you're doing Reiki on family and friends, technically, I know this sounds crazy, but it is true, you still have a duty of care. And that means that on the balance of probabilities, you have given your due attention to someone, you've looked after them, you've been caring, you've done what a reasonable person, given your training and experience, would have done in that situation. And that's the, if you like, the slide rule, the kind of measure which a court would use in judging whether you've been, inverted commas, negligent or not. So, law of negligence tort. It's straightforward. It's based on case law, which means that what judgments have been made in the past tend to affect or influence the outcome of a judgment in the future. And then you probably heard the phrase test case. These things, you know, if there's someone wants to break that chain of case law decision making, then a test case is brought to see if some new case law can be brought in. And certainly one of the most recent things that might vaguely or remotely affect you as a health professional would be the expert witness judgment, which now rules that expert witnesses are not totally immune and they can actually be held responsible for what they say and do. But anyways, that probably doesn't involve any of you. It's a passing interest. Now, the other bit of the law which I think does affect, or let's say it overlights what you do as a practitioner, is criminal law. Now, the criminal law is basically there to protect, it's the state protecting its citizens effectively from other citizens. And in that situation, because the penalties are much more serious, i.e. you could lose your freedom, or you could have a fine, or you would have something on your record, that the burden of proof, as they call it, is beyond all reasonable doubt. I mean, worst case scenario would be a murder, but you know, on the scale, you could certainly say that things such as sexual impropriety or assault, battery, those sorts of things are quite up on the scale. Clearly, someone's reputation can be badly affected if they're judged guilty of something like that. We'll get perhaps into consent a little bit further on, because consent feeds into this whole issue of whether you've actually touched someone with or without permission. We'll talk about that in a little while. I think that's quite helpful for you, particularly as I think most of you use touch, don't you, in your therapy. Louise, just nod if that's the case.
I think some do and some don't. So there are quite a few practitioners who just, if you like, touch very lightly or just hover the hands just above, slightly above the body, and some, it's supposed to be light touch or no touch.
Okay. All right. Yeah, when I had Reiki, someone was touching the body all over, so yeah. Okay, that's interesting. Right. So we're then talking about the criminal law. So other sorts of issues around the criminal law, quite a lot now about discrimination. So you can see you could still be pulled into some kind of legal situation based on what someone alleged against you, whether you did it or not. It's not necessarily whether Reiki is or isn't harmful or whether you did or didn't harm someone. You can see now that someone can accuse you of inappropriate touching, possibly discrimination, and don't forget that now includes things like age, disability, sex, religion, what else? I don't know. There's one or two others there I'm sure I've forgotten. But there's quite a lot on there, which does mean that you have to be a bit careful of some of those issues. And lastly, the other type of law which underpins the UK legal system is the law of contract. That's much more specialised, and it doesn't really touch you overly much as a practitioner. Where I think you get pulled into issues around the law of contract, which is what it says, is where you might be renting a room from someone, so you should look very carefully at the kind of contract you sign. Get it checked by a lawyer, or occasionally I'll do that for clients if they send me the contract they're being asked to sign by a health clinic. That's another situation where you might be asked to sign and hold yourself liable. There are other situations I can think of where you might be working for what I would call a contractor, in other words, a health organisation who brings you in to do certain services under their name. They get paid, you get paid a fee, but there's still a contractual relationship. Other situations might be buying a practice, which probably wouldn't be so applicable to you, But again, if you were coming in and going out of a health clinic, then there are certainly some issues that crop up there when people go in and out, such as who owns the notes, the patient notes, who has access to them, and things like that can crop up. So that's where I think contract law would come in to your possibly your day-to-day practice. Again, these aren't issues that pop up very often, but when they do, they can be immensely painful, difficult, and expensive to get through if anything does go wrong. So it's always good to get these things sorted out before you get into it, even though it's probably not very, well, it's definitely not very interesting, but the downside can be if you don't pay attention to the detail and be very grounded about these things, you can, or the universe might be saying, okay, let's teach you a bit of a lesson here. You know, and you can get these interesting situations that pop up, and then people think, oh, why did that happen? So it's all about learning. That's why I'm very pleased you're doing these CPDs. At Baylands, if any of you looked at our website or come to our annual CPD conference, you'll know that, you know, we're very interested in education and research and anything that can help improve the status, the professionalism, the regard, and the PR for what we're all trying to do in our different ways. So I think that's enough about the law. The only thing that I flagged up for Louise just before we went online is to do with children. And I don't know if any of you treat children, but if you do, the first thing we have to remind you of, if you're not already doing it, is consent. Now, consent is a big issue, and it got bigger and bigger over recent years with issues and problems around the NHS, around doctors, operations, what people do with people's bits after operations, and all sorts of stuff around that. And that's kind of cross-fed into the law, so consent is really important. So I'll talk to you a bit later about that, I think. But how it plugs in with children is, first of all, when we talk about a child, we are talking about someone, normally someone who's under 16 for these purposes. And you clearly must have parental permission. I would recommend written parental permission. Now that's all well and good. Now then there's another issue about should you offer to have a chaperone there in the room at the same time. Some people say no, some people say yes. I've only got about 40 minutes, is it, with you, or 45 minutes left, so I don't think we want to get too embroiled in a debate about that, but that's certainly something you could kick around amongst your colleagues. Certainly in osteopathy, we do a lot of osteopaths in our, I don't know, we've got about 80,000 clients now, so that we do see a whole spectrum from the healing, the energy medicine, and the talking therapies end all the way through to osteo-chiro, you know, occupational therapy and beyond. So these sorts of issues do crop up. But the thing to say here is that with the children, they do also have the ability not to seek parental permission. So for example, if a child said they do not want parental permission to be given, if they are deemed to be mature, have competency, in other words, of sound mind, and clearly have a good idea about their own health needs and their own sense of self and autonomy, then there was a judgment not, well, I think it was about 10 years ago now, and in that judgment it was stated, it was actually to do with contraception. You may have heard of the Gillick judgment, Fraser guidelines they're called, and basically what they say is that a child doesn't need to seek parental permission. So although I think your default position should be get it in writing, check about the parental attitude, whether they want someone there or not, and maybe your consent form could say that. At the end of the day, you don't necessarily, the child doesn't necessarily have to go through that. And there may be situations where the child doesn't want that. You know, not all parents are benevolent, and there could be very good reasons why not. The Gillick judgment all arose around contraception, actually, where the doctor gave contraception to a 12-year-old without the parents' permission, and it went all the way to the high courts and then up to the law lords. So this one is pretty well enshrined, and it's cascaded now out into other areas of dealing with children.
Yeah, it occurred to me, David, at this point, when we're talking about children, perhaps you could include vulnerable adults at this point as well, as that comes under the same sort of area. No?
No, I think with vulnerable adults, you've got a very, well, clearly you will need the guardian's permission, but I think the issue around GILIC doesn't apply here. You would
no.
Because clearly they haven't got competence, so they're not able to have that kind of sense of autonomy and ability to make clear decisions about their own health choices. So that's very much for the person who has legal guardianship.
Okay.
I think also, can I say, while we're talking things fairly legal, and obviously there are lots of laws that will apply. You know, you have consumer protection legislation, you've got health and safety legislation, and so on and so forth. But I think one of the things you do need to understand, and this will also feed into a bit when we talk a little bit about insurance. I keep saying later on as if there's going to be a later on. I hope I can get all this in without overloading you or with too much information and talking. But you do need to understand that if someone is going to sue you, for example, we talked earlier about the law of the law of tort, where someone can sue you for something. They have to do that within 3 years, but it's 3 years of discovering a problem, not 3 years when you did the work. So that's very important to understand, because it has a strong bearing on what kind of insurance you need to take out. So 3 years from the date of discovering a problem. Now, any other claim, so that will be a financial loss or breach of confidentiality, libel and slander, anything else within the law of tort, they have 6 years, again from the date of discovering a problem. Now, if it's involving a minor, then you have to add on the age of majority. And the age of majority from this point of view is 18, just to confuse everyone totally. So you are then looking at possibly 21 years, 24 years. So when people keep asking me, well, how long should I keep my client records or patient records? And after I've finished unrumpling my face and not looking decidedly grumpy when they tell me they've shredded them after 6 months or a year, when I tell them you should be keeping them for at least 7 years, when I say at least, that's because your insurance policy requires you to keep them for 7 years. My advice is you don't actually get rid of your patient notes or records. If I'm feeling a kind of psychic gasp going on out there, the reason I'm saying this is for your protection, not because I'm being pedantic or nerdy about this. The problem is that you can actually get something coming from left field. Not all people are balanced for all of their lives, by the way. It doesn't necessarily mean you've done something wrong. It may be they think you've done something wrong, or they may be totally fantasizing. So, I mean, I always remember at the College of Healing, which I'm involved with, we had a lawyer's letter came in. This legal, what it was one of our healers had done a relaxation exercise where they told the client to, see the sun, and, they were giving this lovely picture to try and relax them. And the lawyer's letter was putting in a formal complaint saying that their client didn't see the light. They didn't see the sun. And it took a few letters before we could finally push that into touch. Now, please don't get me wrong. I'm not saying the person was unbalanced. I suppose it could have been a consumer protection issue that consumer didn't get what they thought they were going to be delivered. But it just shows you that communication and how you communicate and how people hear what you say are sometimes worlds apart. So we talked a bit about statutes of limitation. Let me just explain why I think you shouldn't get rid of the notes. You know, there are situations, particularly you mentioned, Louise, people with perhaps learning difficulties or people without the competency, let's say. Now, there is no statute of limitation if you treat people like that. So you could get, theoretically, it's totally remote, unlikely, but theoretically you could get a claim at any time. And just to be totally ridiculous, but also being careful, because, you know, I'm in insurance, I have to be grounded and careful, I would say to you that I wouldn't get rid of your notes, and I would always let someone that you know where your notes are, and I would also put in your will where those notes are. Because actually, folks, no one can tell what's going to happen to any of us, and your estate can still be sued after you pass on. You could be taxed and you could be sued. So I know I'm smiling. It's a serious matter, but I'm just, you know, these are some of the reasons why I always tell people not to. And the other is, are you really going to remember when 21 or 24 years are up? It's kind of unlikely. So that's why I say these things. I hope those are helpful to you. They're things to just remember, note, do something about, and forget, and get on with the things that you really enjoy. So, where have we got to? Louise, do you want, while I pause for breath, do you want to just say anything at this juncture?
Unmute myself. Yeah, no, that's really interesting, David. And I think this issue of notes is quite a big one, because I'm afraid I do know quite a lot of complementary therapists, not just Reiki practitioners, who actually don't seem to take very good care of their records. And I don't know whether you're going to speak a bit more about records in a minute, but I think it's something that people, like you, I'm a bit grounded and pedantic, and records, you know, are one of the things that I have lots of bits of paper in my office all filed away, but I do think it's important. And I think you're right that everyone has a different kind of energetic makeup, and some people are more grounded and really into all these practicalities, and other people aren't. But of course, if you're trying to run a professional practice, you do need to know about those things, that they are important.
Okay, well, I think then that will be useful to talk a little bit about records. Now, I'm not sure what Reiki people are taught in terms of what kind of records they keep. But if I tell you from, if you like, a legal insurance perspective, what we will be looking for, and what the insurer or a defending lawyer will be looking for, then that's probably a helpful place to start. Whether you choose to do that or not is entirely your call, because you know, we're not in the basis of creating fear or anxiety. But this is a reality check. The notes have to be clear. They have to describe the story. That's the way I like to talk about this, describing the story. And it doesn't necessarily need to be pages and pages like you might expect for a counsellor or a psychotherapist. But it needs to be objective rather than subjective. Even if you're very intuitive or psychic or telepathic or whatever it is you might be able, gifts you have, to put in your notes, I felt they might have cancer, or I felt that there was a problem with their boyfriend, or I felt this, or it seemed this, that, or the other. If you're going to write any descriptions about what happened, then I would avoid those sorts of statements. If you want to keep a record of that kind of material, in other words, the subjective material, or indeed psychic material, or any of that, what I'd suggest you do is you keep a separate diary where you can write this kind of stuff in, which is your private diary. No one has to know it exists. It's certainly not relevant to the patient, the professional-patient relationship, but it can be to do with your own reflection and your own way of learning and developing. And remembering, because let's face it, we can't always remember everything that went on. I would suggest also that the records, they should be a bit more than gave Reiki, client said they were okay. I think there's a little bit more in there. You need to show that you've understood them a little bit. You need to show also that you've explained to them what Reiki does. And I would say the easiest way to do that is to have your own booklet where you've got the material already in there, so that you don't have to keep saying the same thing over and over again, which we all know can be quite tedious. It can also start to sound parrot-like after a while, a bit machine-like. And you want that warm, empathetic, engaging, therapeutic relationship, which I'm sure you will give. But I'm just reminding you that if you're going to introduce this kind of element and be a bit more grounded, you don't necessarily have to lose who you are in that process. The booklet, again, is another reflection, I think, of who you are, and it's a grounding of your approach. It also explains what it all is, gives them the chance they can ask questions rather than just doing the Reiki and not giving them any build-up or explanation beforehand. Because again, we talked about consent. This is all part of what I would call an informed consent. Now, these phrases keep changing, but I think the giveaway is in the phrase. You're letting people know so that they can make a choice. And consumer protection, I'm afraid, is in there as well, yapping around our heels somewhere in the background. This whole thing about fairness, equality, we're in a position perhaps of power and knowledge, and that we can maybe be seen from some quarters to be abusing that in some way if we don't bring people into the process. So I think when we're talking about professional, now you might think, okay, if I'm doing work on my relatives and friends, surely I don't need all this rigmarole. Well, again, it's your choice. All I would say is that you should still keep notes, okay? The reason being, even if those notes are fairly basic and perfunctory, it at least shows that on such and such a date, you did such and such a treatment. And even with family and friends, things can change, let's say. So I think this is all about protecting you folks. This isn't about Big Brother David and the insurance industry saying you must do things a certain way. After all, the policy is there to protect you. Risk management is really about helping you organize your life so that you can minimize potential negative stuff. And I believe it also builds a kind of an aura around you of groundedness and balance, which I think, if it's done in the right spirit, is wholly therapeutic. And I call this financial therapy. So you have to bear with me on this.
Yeah, I think that's really helpful, David. I mean, I do explain to people what they might expect and what might go on, but I don't ever document that anywhere. So you're right. If I had a leaflet, I could just gave them the leaflet, then you'd know that they'd had that information.
I would then add a line under that saying client read and didn't have any questions, or client read and said great, or what have you. Now, I know in America and various places they do try and get the client to sign an agreement to have the treatment. I think from my perspective that's not really necessary, although some people like to do something like that. If you are going to do a consent to treatment, for goodness sake, don't follow the American model where they said, and I'm not going to be held liable for anything you might do to me, so help me God. I think some of those are very much in breach of English fairness, and anyway, consumer legislation would say that's an unfair contract. So
yeah. Okay, so what I do, David, I have a little piece at the bottom of my form, and it says, it's for them to sign. It says, I understand that complementary therapies are not a substitute for medical diagnosis and treatment. It's something like that. I think it's something like that, so that, I have explained to them that, if you like, the limitations of complementary therapies, and that, if they have a serious condition, that this isn't something that, they should be getting a medical opinion if they haven't done so already.
I think that begs the question, do Reiki people usually take what will be even remotely described as a case history before doing a
Well,
Reiki treatment? I know if they're a multi-therapist,
yeah,
they might, but would they do that if they're doing Reiki?
well, I do, but I don't know that everybody does. I think because there's no standardized training for Reiki practitioners, there are guidelines, but people do different things. I think it depends on the individual practitioner. Yeah, but that's something that I've always done.
Okay, fine. I mean, clearly that could be something which we can all go on discussing for quite a long time.
Yeah.
I think the more info you can gather, the better. I think it's good when you say this is no substitute for the doctor. Some complementary therapists would never put anything like that in, of course. I mean, there's some, as you know, are alternative systems of medicine dating back thousands of years. But, but I do think you need to find out a bit about why the person's come and whether you put some kind of disclaimer in along the lines that you just said is again purely a matter for the person. I think, you know, it might be helpful for the Reiki Guild to think about a few general questions that you could standardize for all the members to use. Give them a template and they can just whack it out in Word for themselves, stick their own logo on it. And maybe also a standardized information sheet about what is Reiki, what to expect, what not to expect. A little bit of precautionary stuff, like you might feel a bit, my words, spaced out afterwards, or you might feel relaxed. Or I think the thing to say is that you're never going to stray too bad if you go into using the wellness word or the well-being word as well as health. I think in my understanding, the conventional world is more comfortable with well-being and wellness than medicine or complementary medicine. I like to think of it as natural medicine rather than complementary, but we all have our buzzwords, and you know, I think we'd all love it for just to be medicine or looking after people, and there's different people on that spectrum, but I think those days are long ahead in the future. So, okay, is that enough, do you think, on record keeping?
Yep.
It's important, just to recap, if you want to reduce complaints, if you want to reduce confusion, if you want to build a therapeutic relationship, in my humble opinion, taking time to explain a bit about it, particularly for newcomers, obviously, and also to just guide them through what would happen very briefly, and at the end, they need to relax, not maybe to drive straight away, just to make sure they're well and truly grounded. Anything you can do before and after treatment is really important, because the number of complaints and claims we got across the board, we don't get many in healing and Reiki, I have to say, but and they would be more behavioural than actual to do with the therapy, conduct issues. But you know, it's really important to manage the relationship in that way, so people are informed. It's noted briefly in the records, and then if anyone ever challenges you, you've got something to protect you, and that's really the purpose of this advice. So, shall I talk a little bit about the insurance, because it does plug into this. First of all, the scheme that you'd have with us is a scheme I devised many years ago. It's been built over some 24 years when we first tried to pioneer this at a time when we were all quacks and it was fringe medicine, and it was all, well, in fact, we're still getting it called voodoo medicine, I think, is the latest. Things like that. Great stuff. At least we're not getting burnt at the stake for it anymore. Anyway, the policy is there to protect you, and the policy wording you've got is as good as anything virtually that a conventional medic would have. It has defined sections, and they cover different areas that you could be held to be vulnerable or liable under tort, as we mentioned earlier. So what are they? Well, medical malpractice is about people saying they've been injured or harmed, or remember, this can be mental or emotional as well. I'm sure we all agree energy medicine is not some fairy dust that's, you know, it can be quite powerful in its effects. And if people are unbalanced, in my experience, that can unbalance them further in certain instances. So I think we have to be very mindful of this, really. So medical malpractice will cover you for those sorts of allegations. Whether you did it or not, it's there. And the mere act of complaining, which in my book is, a complaint is something where there's a threat of taking it further. It's not a moan or a niggle, okay? And there are ways you can handle moans and niggles, which again, it keeps going. Maybe I'll talk about that later. But I'm just talking about this policy wording at the moment. Medical malpractice, public liability is the slip and trip. Louise, in our chat earlier, you talked about couch collapsing. That will be a public liability claim. It wouldn't be an indemnity claim. The other thing you get is professional indemnity cover, and that again is about financial loss and about libel, slander, breach of confidentiality, loss of reputation we cover, and things like that. Product liability doesn't really apply to you, but if you were doing massage therapy or herbalism or anything where you're, or homeopathy, those product liability would cover some defect in the product injuring someone. So that's the kind of cluster of the main kinds of cover. There are all sorts of other bits and pieces in there which I'm sure you'll study your policy wordings after this talk deep into the early hours, and I'm very happy to take questions on that. In terms of the criminal law, we add a package to deal with that, because the normal public liability, treatmentless, professional indemnity, those policies only cover negligence law. The DAS commercial legal protection we give you, that covers allegations of inappropriate touching, touching without permission, that's assault or battery, and discrimination issues and things like that. So all of those are picked up and you're defended up to a certain limit. I talked about things that could happen from before. In our policies, it covers you for whatever you did before, as long as you were insured for the work you did. And interestingly, it also covers you if you stop practice for an unlimited time afterwards. So this issue about if someone tries to sue your estate 40 years on, the policy will still cover you for that, even though you've stopped it 40 years ago. The criminal stuff doesn't quite work that long term, but then criminal issues, there's no statute really for a lot of criminal stuff, so these are very hard to do. But generally, if someone wants to have a go at you for something like that, they tend to do it fairly quickly in our experience. Okay, I'm wondering whether we should take some questions, as it's about 45 minutes of me rambling into legal and insurance-y places. Oh, one other thing before I stop that I think could be relevant to you, and that is if you work from home, which I think quite a few Reiki people might well do, apart from there are potential issues with local government taxes if you are taking money, and if people are coming in and out all the time. Ideally you should be paying business rates on a proportion, a very small proportion. But more important perhaps is the fact that your household policy, unless you get permission from your insurer, your household policy normally won't cover unless you tell them and you get their permission. Some of them will restrict it to so many people a week, some of them don't, and some of them don't want you at all. So I'm just mentioning that because it could be something that crops up.